Oh, yes, oh, yes, oh, yes. The Honorable Court of Appeals of Tennessee is now in session. God save the United States, the state of Tennessee, and this honorable court.
Good morning and welcome to the Tennessee Court of Appeals. First of all, I want to tell you how much we appreciate you agreeing to participate with your oral argument via Zoom. I think it's probably the best way for us to keep the cases moving at this point in time. I also want to thank you for agreeing to schedule this case for hearing on such short notice. I know it was scheduled last month and we had a vacancy develop, and I appreciate all of you jumping in and agreeing to present your argument today. Since we are doing this argument via Zoom, I want to reiterate simply that the same rules, the same procedures that we would be utilizing in the courtroom apply here today. By that, essentially, I mean each side gets 15 minutes to make its oral argument. If you're the appellant and you've reserved rebuttal time with the court previously, you'll receive that rebuttal time. I also want to tell you that if any technological problems develop, which we certainly don't anticipate happening, but could, everybody just be calm. We will fix those problems and we'll make sure that nobody's prejudiced as a result of those problems. Before we get started, though, I'd like to introduce our panel for this morning. We have Judge Arnold Golden from Memphis, Judge Kenny Armstrong from Memphis, and I'm Steve Stafford from Dyersburg. Ms. Angie, anything we need to take up before we call the case?
No, Your Honor.
You may call the case then.
Anthony Walker et al. Versus Rivertail Crossing Homeowners Association, Inc. et al.
And is the appellant ready?
Appellant is ready, Your Honor.
All right, we will hear from you, sir. You may proceed.
Your Honor, this case involves an incident that occurred on common area owned by Rivertail Homeowners Association. Rivertail, there's a retaining wall located on Rivertail common area property completely. There's two reasonable inferences from the facts that have been asserted regarding construction of that retaining wall. One is that the developer built it. Two is that the homeowner's contractor built it, even though it's on the common area. In order to build something on the common area that requires clearing and digging, you have to get written consent from the homeowners association. So if written consent is given, there would be plans and they would be aware that there is no French drain on the retaining wall. So under either circumstance, for the reasonable inferences for construction, it either provides Rivertail is responsible for it, or Rivertail has knowledge that there's no French drain in the retaining wall. And I would submit, even if it's constructed on their property by consent for the homeowner's contractor, that once you allow somebody to build something on your property, you approve the plans, you're responsible for it. So they're responsible under either instance for the reasonable inferences from the facts that we've set forth in the brief as to causation of the erosion without a French drain or aggressive erosion along the French drain wall that caused the trough. They're also responsible for maintaining the landscape planning. In this case, 8 months before this, Mr. Walker put him on notice that there was a problem with the Vinca. He talked to Jose Franco. He also followed it up with a text message a couple of weeks before the incident actually occurred, and they said they would get to it. These are the facts in light and most favor to the plaintiff.
Who was it that he notified?
Jose Franco.
And
I'm sorry, Your Honor.
And who was that?
He was a board member at the time.
Okay. And
a next door neighbor. And he was also present on the video after the fall.
I understand. Was there some agreement about the board member presenting this to the board, or was this a neighbor discussion? How does that all play out here?
They were discussing board member issues. The board member was telling me he's having construction at the back of his property and had put the board on notice about it. And he responded text that I've got this issue that needs to be taken care of. And Mr. Franco responded by text that he would remind him about it. 8 months before that. And Mr. Franco was on the board, and Mr. Walker knew he was on the board. He knew he was approaching someone on the board. The issue with landscaping.
Let me ask you, this notification that you just talked about, that was not notification that there was a problem or that the ground in that area was uneven, was it?
No, it was not. It was the covering up of the uneven ground by the overgrown landscaping.
I mean,
but it had nothing to do with the ground.
Right. Looking at the briefs, it appears that your client lived next door to this area for approximately 20 years. Is there any proof in the record that he observed something that should have alerted the homeowners association that there was something wrong in this area, that the ground was uneven?
Nothing that the ground was uneven. There is testimony that it was regularly maintained by landscapers prior to 2016, that the grass was cut on the common area, which was the only person who could cut that, with the exception of the easement, would be the homeowners association or their contractor. The homeowners association had prior contractors before. They have no records as to who they were, or don't know who they were, so we can't go and talk to them and see what they saw and what they knew. And they're the only ones that have that information. We asked them 3 different times.
Right. Did the homeowners association rules prohibit your client from doing what he did?
No, there's an easement allowing for encroachment, Article 9, Section 3, that when there's an encroachment on the property, you have a right to go in and cure it, whether it's settling, whether it's a building, or whether it's overhangs. You're granted an easement. It's not, I think they got 10 and 9 backwards in the articles. If Article 9 were the one that said subject to the following provisions with landscaping, and then followed it with the easements, because it has a utility easement in there. And obviously utility easement, they can destroy landscaping when they come in to put utilities in. But I think whoever drafted it got those 2 provisions backwards. And that's why it says subject to the following provisions in the following paragraph in Article 10, Section 2, and it goes nowhere. The following paragraph doesn't do anything. And the first easement says subject to the following provisions, which allows Rivertail, or BICO, actually the one drafting it, to put restrictions on that easement of enjoyment in Article 1 or Section 4, I believe. Maybe it's Article 4, Section 1. So subject to is used in there for limiting language already in the restrictive covenants. So it should be interpreted the same way, that this was going to put limits on the architectural committee could do with regard to approval. And it does says nowhere in it that it's written. That provision would not be needed if the Article 7, Section 1, dealing with non-landscaped areas, was dealing with landscaping. So when it's 2 possible interpretations, you take the one that is least restrictive. And I think the subject to paragraph leaves it wide open. The president of the board said all they had to do was talk to him, and he would tell them they wouldn't get authority, but he'd tell them to go ahead, they'd go ahead and do it. How's that not approval? He said that's what happened 6 years earlier when there were tree limbs overhanging the property, and he told Mr. Walker he could do it, could cut them back all the way to the property to the tree trunk, but he wouldn't get authority to do it. And then he said Tennessee law does that, but also Article 9, Section 3 would have given authority to go out onto the property and to cut those limbs back, which is the easement given to homeowners and to the association.
To your knowledge, was there any such approval in the past for someone to engage in the conduct that the appellant engaged in, where he's using a lawnmower to cut vinca in a common area? Can you cite any examples where that was allowed in the past by the homeowners association?
Not with a lawnmower and vinca, but he was allowed to use chainsaws and cut the limbs back on the property 6 years earlier.
But with that, I mean, you could clearly see what limbs needed to be cut. I mean, we're talking about vinca now, ivy that's spreading and growing. That would be different, wouldn't it?
I think it is somewhat different, but under the case law and the encroachment, if it encroaches on the property, I think it's similar under that circumstance, that it would allow them to cut both.
And you could foresee that somebody would attempt to use a lawnmower to do that, and not a weed eater?
Well, I believe you could foresee that they would use both. The landscapers used weed eaters and mowers, and Nelia said that his people would probably use a weed eater, but he'd find if they used a mower to go over it when he was asked about it in his deposition. So I think it is foreseeable. I think the landscape contractors had been in there doing things, cutting it for 18 years, and they just stopped doing it.
Let me follow up on that. What kind of evidence do we have about the prior landscape contractors being in there and what they did, and essentially what's the evidence in the record about that?
It is just that our clients saw people over there taking care of the landscaping for 18 years, and that it was taken care of. The grass was cut. New people came back and were cutting the grass and no longer cutting the vinca. We were not given the name or any records in discovery as to who the prior landscape contractors were, despite the fact that Mr. Bradshaw was president for 4 years during 2 of those landscape contractors, to go ask them what they saw and did they in fact cut the vinca. Our people, with their 18 years, the vinca was cut. It's a reasonable inference that it was cut by the Homeowners Association had authority to do it, and by the contractors that were out there doing it. I think that's a reasonable inference for summary judgment purposes.
Is there a dispute about that in the record? Or is there any dispute that they did in fact maintain the very area that we're talking about?
I think the only thing they said is they didn't know.
Okay.
So I would say there's no dispute.
All right. Thank you.
With regard to the protective order, our clients filed suit. They're litigants. They did not file a claim with an insurance company. They filed suit against Rivertail and Nelius. And as such, they're not consumers under the regulation. And if they're not consumers, then they don't provide any non-public personal information. That's definition 6 and 9 under 0780-01-04 or 12. Forgive me, I only have 3 seconds, so I don't have time to look it up. But
Well, let me ask you, did your clients produce any medical records during the discovery stage in this proceeding?
they have not. We requested a protective order prior to producing.
So there've been no records produced.
Correct. And that's the second part of the definition, that you had to produce some sort of non-public personal information to be
Okay.
a consumer.
All right, thank you, sir. You have used your initial time. You have your rebuttal time. We will hear from the appellees, and I assume, gentlemen, y'all have decided how you're sharing your time and who's going first and so forth.
We have, Your Honor.
All right, and can you share that with the court, please?
Yes, Your Honor. Thank you, and may it please the court. My name is Dylan Gillespie. I represent Rivertail Crossing Homeowners Association. I will be arguing for 10 minutes, and I have reserved 5 minutes for Mr. Joy and Mr. Lyons to argue.
So they're going to split the 5 minutes.
Yes, Your Honor.
Mr. Lyons is shaking his head.
Your Honor, may it please the court, we are going to allow Mr. Joy to use the bulk of the remainder of the appellee's time. Our understanding of the rules was that if there were going to be more than 2 parties presenting from the same side, that we had to file a motion, and no such motion was filed. So Mr. Joy will use the 5 minutes for both ANPAC and State Farm.
All right, thank you. Appreciate you clarifying that. All right, Mr. Gillespie, you may proceed.
Thank you, Your Honor, and may it please the court. This appeal is before the court on the grant of Rivertail's motion for summary judgment. That motion was granted on 2 bases. The first basis was that the covenants, conditions, and restrictions of Rivertail Crossing Homeowners Association grants Rivertail Crossing the exclusive control over the common area, including landscaping features and the maintenance of the common area. And specifically, Your Honor, the covenants, conditions, and restrictions require, in several different sections, require written approval before a homeowner interferes with an unimproved portion of the common area or with landscaping features on the common area. It's undisputed here that Mr. Walker did not obtain written approval prior to attempting to mow the area of common property that is next to his property. So that was the first basis that the trial court granted the summary judgment on. The second basis was,
How did the trial court deal with his conversation with the board member?
certainly, Your Honor, the specifically with regards to the conversation Mr. Walker had with Mr. Jose Franco, Mr. Franco testified that Mr. Walker mentioned the ivy to him and wanting to have the ivy cut. Mr. Franco testified that he advised Mr. Walker that he should submit that wish or that concern to the board in writing so that at the next meeting, the board as a whole could take it up. And as far as Mr. Franco is aware, and as far as Brad Bradshaw, who is the president of Rivertail Crossing Homeowner Association, as far as he is aware, no such written request or written notice was ever submitted to the board.
The appellant mentioned some text messages going back and forth. Are the text messages consistent with that finding?
Yes, Your Honor. The text message that was referenced, I believe that is the one that was sent 1 or 2 weeks prior to the date of the injury. And it is consistent with what Mr. Gilder said in that Mr. Walker mentioned the ivy to Mr. Franco, mentioned that he wanted to have it cut by the landscaping personnel. And Mr. Franco, by text message, did not respond that he should put that in writing. That was a verbal conversation on another date. And Your Honor, I do not specifically recall what Mr. Franco's response was to Mr. Walker's text message at that time. But in any event, what we're left with is that the board as a whole never took up the issue. It was never considered by the board, and the board never voted on it. And in fact, Mr. Bradshaw testified that he was not even aware that Mr. Walker was concerned about the ivy or had an issue with the ivy until he was served with the complaint for this lawsuit. And so, Your Honor, that is, for lack of a better term, that is kind of the overarching issue here, is the issue of the covenants, conditions, and restrictions that forbid interference with the common area or common area landscaping features absent prior written approval, which Mr. Walker did not obtain.
Well, that leads me to what I understood appellant to say is that in fact is not what the bylaws say, that the bylaws allow the homeowner to do what the homeowner attempted to do. Did the court deal with that issue or deal with the import of the language of the bylaws?
The court did not, Your Honor, not at least not explicitly. I believe the particular provision that was cited earlier, Article 9, Section 3, regarding encroachments, Your Honor, that provision does not concern homeowners. That provision states that there is an easement retained for encroachments that are for certain repairs or construction that is designed or constructed by the declarant. And in the covenants, conditions, and restrictions, the declarant is the developer, BICO Associates, who conveyed the property on a later date to Rivertail Crossing Homeowners Association. And so that provision, while it does address easements and it does address encroachments onto properties, what that provision is saying is that the developer and then later Rivertail Crossing has an easement to encroach on properties for things such as, and I believe this was cited earlier as well, things such as utilities or fences or really any construction at all. The provision is not narrowly tailored and it's not specific to any one type of feature. It just mentions construction or repairs. And so as far as the plain language of the covenants, conditions, and restrictions go, there is no workaround to the requirement that written approval be given before a landowner, a homeowner, can interfere with the common area or with the landscaping features. The other basis that the trial court granted Rivertrail's summary judgment on concerned the issue of notice or knowledge of a defective condition. And here we get into the covenants, conditions, and restrictions again just a bit, because there is it's undisputed that there was no actual knowledge of the uneven area alongside the railroad tie on the retaining wall. No one knew that that was there. There is some dispute as to who built that retaining wall. But Your Honor, I would submit that issue is not dispositive and possibly not even relevant, because regardless of who constructed the retaining wall, what it comes down to is Rivertrail intended for this ground ivy, this vinca, whatever it may be. Rivertrail intended for that to be present. And there's testimony from Mr. Patrick Nelius, who is the owner of the landscaping company that Rivertrail contracted with. There's testimony from Mr. Nelius that the purpose of that ground ivy is for erosion control, and that to effectively control or prevent or lessen erosion, that ivy has to be maintained at a certain length or a certain height, which I believe is 8 inches. And so as far as whether the ivy had been cut prior to 2018, whether some other landscaping company had cut that ivy at some point in time, again, I don't believe that is particularly relevant here, because Rivertrail, having the exclusive control of the common area property and the landscaping features thereon, has the ultimate control over whether it wants the ivy to be allowed to spread or it wants to keep the ivy cut back to the wooded area. The ivy that we're talking about alongside the retaining wall, it comes out of the wooded area that's in the center of Rivertrail Crossing. And so
let me ask you a question, Mr. Gillespie. How does the fact that I assume is undisputed for purposes of the summary judgment motion, that previously that had been cut back by another landscaping company, how does that impact your argument?
I don't believe that it does at all, Your Honor. And as far as who or when or if that ivy had been cut back previously, we really don't know. That there is testimony from the appellants that they had seen people over there previously and they appeared to be cutting in the area where that ivy is. But Rivertrail is not aware of who that person or who those persons were. It is not aware of when that last occurred or who instructed that person or that landscaping company to do so. But even assuming that was the case, assuming that there was another landscaping company that prior to 2018 had kept the ivy trimmed back to that wooded area, that certainly does not create an obligation upon Rivertrail to continue having the ivy cut back. If at some point in 2018 or 2017, if at some point Rivertrail determined that it was better for erosion control to allow the ivy to grow, then certainly pursuant to the covenants, conditions, and restrictions, they were allowed to do so. And for those reasons, Your Honor, I would ask that the court affirm the trial court. Thank you.
Let me ask you one question along what you just concluded in saying, and that is, does the record, the minutes of the board reflect that any decision was made to do anything different than what the appellant alleges was done before? In other words, was there some discussion about a change in the way the landscaping was being conducted?
Not to my knowledge, Your Honor. We do not. I do not have the minutes from the meetings prior to when Solo Landscaping assumed the contract for Rivertrail Crossing. I have minutes from around the time of this incident in April of 2018, but nothing prior to that. And the testimony is that Solo Landscaping has been the contractor for Rivertrail I believe since at least 2017 or 2016. So that would be minutes, I believe, from probably 2015. And we do not have any of those at this time, Your Honor, and none of those are contained in the record.
All right, thank you.
Thank you.
We will hear from Mr. Joy, I believe.
Thank you, Your Honor, and may it please the court. I'm Justin Joy here this morning on behalf of State Farm Fire and Casualty Company. As previously introduced, Mr. Lewis Lyons is here on behalf of American National Property and Casualty Company. We are the intervening insurance companies in this case. Your Honors, in its two-sentence reasoning, the trial court correctly stated why a protective order should be denied in this case. First, a protective order would not provide any benefit to the plaintiffs not already provided by existing law. Second, relatedly, the requested order would be superfluous to the existing protections afforded by the Health Insurance Portability and Accountability Act, HIPAA, and even more so, the Gramm-Leach-Bliley Act. There was no abuse of discretion in the trial court's determination of this discovery-related issue, and as a result, this court should affirm the denial of the plaintiff's motion for protective order. While the intervening insurance companies, State Farm Fire and Casualty Company and American National Property and Casualty Company, provided additional reasons in their briefing to the trial court and this court as to why a protective order should be denied in this case, the reasons articulated by the trial court are sufficient grounds for justifying the denial of the motion. I want to briefly address a point raised by Judge Armstrong about whether the medical records have been produced in this case. And as Mr. Gilder responded, they have not. And it's State Farm's position that if this court should affirm the summary judgment determination, then this issue on the protective order is pre-termitted. I also want to address a point that Mr. Gilder raised, that his clients are not covered under the Tennessee regulations, but they are, Your Honors. If you look at Rule 4 of the Tennessee rules here at issue, and I am referring to the Department of Commerce and Insurance Regulations, the Insurance Division Rules, which is Chapter 7801, Chapter 72. Again, Rule 4 says that an individual who is a claimant under an insurance policy issued by a licensee, such as State Farm or AMPAC, is a covered consumer under these regulations. And that is exactly the position that Mr. Gilder's clients fit in. So again, Your Honor, their existing law does provide for protection for the medical records at issue, and the motion was properly denied. In their brief to this court, the appellant's almost exclusive reliance on HIPAA is misplaced. Yes, HIPAA does protect the appellant's medical records while they are in the possession of the appellant's healthcare providers. However, once those records are disclosed pursuant to a medical information disclosure authorization or other permissible purpose, HIPAA becomes irrelevant. When those medical records are received by insurance companies, such as the interveners, although HIPAA is no longer relevant, another privacy law scheme is. As established in the briefing of the intervening insurance companies and as recognized by the trial court, the Gramm-Leach-Bliley Act and the related state laws and regulations implementing the Gramm-Leach-Bliley Act automatically protect any non-public personal information, such as medical records, disclosed in litigation and obtained by insurance companies. As correctly stated by the trial court, a protective order would be improperly superfluous to these existing obligations. Respectfully, in contrast, appellants incorrectly downplay and mischaracterize the privacy protections afforded under these financial institution regulations. Additionally, a protective order requiring the return or destruction of medical records at any point after the conclusion of litigation creates an impossible conflict with the intervening insurance companies' obligations under other law, as well as impairing their fiduciary duties owed to policyholders and other constituents. The trial court correctly recognized the privacy protections afforded under existing law, and the entry of the requested protective order would be superfluous and improper. This court should affirm the trial court's decision to deny the plaintiff's motion for protective order.
All right, thank you, sir. We will hear from the appellant in rebuttal. Mr. Gilder. I think you're muted. And you're still, there you go. I believe you're okay now.
As to the provision in the restrictive covenants, Article 9, Section 3, each lot and the dwellings located thereon and the property included in the common area, there's an easement granted. Why would the declarant, BICO or Rivertail, need an easement into the common area? They're the full owner. If it only applies to BICO going in and being able to do it. Since it's a dual easement, it applies to the lot owners and to the association. So we have a right to come in and take care of encroachments.
Was this argument made to the trial court as well?
The specific provision was not cited to the trial court, although the entire restrictive covenants were in there. We argued we had an easement that had not been negated to the trial court.
And did you explain what you relied upon for that easement?
I did not.
Okay.
That was our provision that had not been negated. And even if the provision was negated, the provision they're relying on, Article 10, Section 2, is ambiguous at best. It doesn't say written approval. There's 7 times where it says written approval in the restrictive covenants. It just says approval. And Mr. Bradshaw said approval was you come to a board member, you ask him to do it, you don't get it, but you do it. Now, Mr. Franco said you had to go to him, but he never told our client that you had to go to him under the facts and the light most favorable to the plaintiff. He just said he'd take care of it by reminding him to take care of it.
Was the ambiguity argued to the trial court?
Yes, the ambiguity was argued to the trial court. And I think the best interpretation of what they intended for the rules would be for the easements to come in after, because that's logical, subject to the following provisions. Would have easements to allow you to go through the landscaping without having to get approval of the architectural committee. And that was argued. The architectural committee does not exist. There were no provisions or procedures for how that approval was to be given, set forth in the subject to paragraph. And it's used in the restrictive covenants as limiting language in Section 4.1 where the general easement is given. So it should be limiting language again. And there are no limitations that follow it. So we would argue it's ambiguous and would allow restrictions. And it would allow tacit approval as described by Mr. Bradshaw that he gave regarding the tree limbs and would have given regarding any situation. He took no action when there was a board member present when the area had been cut by Mr. Walker. So they actually tacitly approved what had been done this time. With regard to the HIPAA regulations, protecting information once it's released, if you sign a release saying it's subject to further disclosure without protection, which was the type of releases that were asked, there is no HIPAA protection. HIPAA governs protection within the court under 45 CFR 164-512E1. If a record is subpoenaed, you can object and request a qualified protective order. The qualified protective order requires the records to be returned at the end of the case, and they only be used for the case and retain their confidentiality. The court has dealt with the Medical Malpractice Act, which has provisions, and found that the provisions requiring the records to be destroyed and kept confidential are in line with HIPAA. They've said filing a lawsuit does not waive the HIPAA protections. Let's see, Wilford versus Klepper 2020 case clearly states that. So it's our position that the HIPAA protections stay, that, and also Tennessee has confidentiality and privacy for medical records. Shouldn't a protective order be granted as to, even if the insurance companies have additional protection, shouldn't it have been granted as to Rivertail? Should my client's medical records be public information for all the members of the Homeowners Association? Should they be restricted at all by counsel? The protective order didn't just deal with the interveners who are not parties to the lawsuit and would not be given any information directly by the plaintiffs. It dealt with everybody. And in that base, it was an abuse of discretion. I think a protective order is appropriate for medical records, especially when you're not limiting the medical records to the ones that are relevant to the specific injury, but are discovery relevant to see if there's any pre-existing conditions or other issues.
All right, does that conclude your
Let me
argument?
ask, Mr. Gilder,
Oh, go ahead.
is it undisputed that the Vinca was there to help to prevent erosion? Is that disputed?
It is a ground cover to help prevent erosion. It's not disputed.
All right, is there any proof in the record regarding when the ground started to erode in that area and become uneven?
There is not, but there is testimony from Carmen Scruggs, a landscaper for 40 years who's built retaining walls, maintained retaining walls, maintained landscaping. He identified it as Vinca. It's not native. He also said that when it had been cut approximately 2 years before, whoever cut it would have seen the trough. So he said it would have been there at least 2 years.
Let me ask you, is there a walking path along where this Vinca was planted and the railroad ties were installed?
It's a few feet away and it gets closer as it goes back. The lots at the very back end are probably 30 feet between the two areas, and the walking trail comes in and goes out through that area. And it bends around behind the retaining wall to the level ground behind our client's property. So it's never more than a few feet away from the Vinca.
And you can see the railroad ties, even though you have Vinca in that area where we're talking about.
Yes, from my client's side, he could see only the railroad ties when the Vinca was maintained. I mean, he could see the Vinca on the other side, but it grew over the railroad ties.
Okay.
All right, thank you, gentlemen. We certainly appreciate your oral argument. We appreciate you agreeing to schedule it so quickly and by presenting it via Zoom. We will endeavor to get you an opinion at the earliest possible date. Ms. Angie, anything we need to take up before we recess to the call of the next case?
No, Your Honor.
All right, you may recess court then. Thank
This
you again.
honorable court is in recess until 10 a.m.
Thank you, Your Honors.